and Nick Pickles to the dais. It is very unusual for this committee to have members of Parliament before it. The reason why we've asked you to appear before us today is because of your knowledge about these issues. And Mr. Pickles, thank you very much for coming. I'm sorry we're running a little late, so you will appreciate the fact that members of this committee will ask robust, quick, sharp questions, and we will get quick, sharp replies, which we're very used to, Mr. Davis. Could I start with you, and that, Mr. Davis, in the publication of the Snowden files, and generally the architecture of scrutiny? Do you think that what we have at the moment is enough as far as the ISC is concerned, the commissioners you've just heard from one of them? Or do you think we should toughen it up and make it different and better?
No, Mr. Chairman. Much of what my evidence today is based on a visit to the United States to look at the impact of Snowden files there. I should say, as a declaration of interest, that trip was paid for by Big Brother Watch, by the way, so if you'd register that. And the arrangements there, although they are criticised in the States for being insufficiently robust, are 1,000 times more robust than ours are already. There's much more public information available, qualitatively different levels of public information. There's more rigorous oversight by many more organisations than you've heard about here. There are legal protections for the privacy of citizens, which don't exist here. There's constitutional bar on general warrants, which we don't have here. There are proper separation of powers, so the legislators actively challenge the executive in the interpretation of the law, something very important on the torture issues as well as other issues, and of course for something we cannot reproduce, they have a far stronger IT industry than we have here, who have strong vested interests in making sure that surveillance is not misused.
So your top three changes to what we have at the moment, including parliamentary scrutiny, would be what?
Well, would be significant beefing up of the ISC, including its method of appointment.
So are you favour election by the House?
I'm in favour of election by the House. I don't mind the Prime Minister nominating, having a say at the nomination stage, so that, for example, if I were a well-known communist spy, I could be knocked out at the beginning, as it were. But I don't mind that, but I think the House should choose. I agree with the notion put forward by the Shadow Home Secretary that the chairman of it should be a member of the opposition, as with the Public Accounts Committee. Indeed, I think the Public Accounts Committee has a lot to offer here. But I also think something which came up was said to me by a member of the President's panel. And he said one of the great virtues of the American system is that there is more than one oversight committee. So you have the two oversight committees in the House and Senate, but you also have the Judiciary Committee with an insight to it. And it was a Judiciary Committee in the latest scandal which provided the most important piece of evidence, namely that the so-called 54 cases stopped by the surveillance, or claimed to be stopped by surveillance, were actually untrue. That there are actually 0 cases stopped by the...
Mr. Pickles, top three changes?
Well, I think the first one, and I agree with the President's review, is you end bulk collection. You go back to a system which is warrants are targeted on individuals, on premises, and you do not collect information in bulk. And from the US trip, the two things that became clear is there's different kinds of bulk collection. There's bulk collection without the consent of companies, and there's bulk collection by ordering companies to hand information over. And late last night, I received a letter from the British Telecom refusing to deny that they are handing over information in bulk on thousands or millions of British citizens. And that mirrors a refusal to deny the same situation in a parliamentary answer received by Mr. Davis. So I think ending bulk collection and then introducing judicial authorisation for warrantry, particularly on interception. So we don't have the situation we've just seen where retrospective authorisation or by a retired judge. You have an actual judge hearing evidence, both sides' evidence. Again, the President's review made clear the danger of one-sided courts. And then finally, I wholeheartedly agree, rigorous oversight outside the agencies that must include parliamentary oversight. And one of the nuanced changes that struck me was the remark by the staffers from the members of the Senate Intelligence Committee, who said the difference it makes by individual members of a committee being able to hire their own member of staff who has security clearance. and the difference that makes, rather than relying on a collective clerking staff provided by the agencies.
Mr. Davis, were you glad when The Guardian published the Snowden revelations?
Well, I think The Guardian did a public service by publishing the Snowden revelations. And indeed, bluntly, I think the government was heavy-handed in dealing with them. I think if you look at every other country in the world, the newspapers that have brought this to the fore have been feted. They have been up for Pulitzer Prizes. They have been seen not just by their colleagues, but by the public and by the governments involved as having done a service. This is the only country in the world where the government has taken the opposite view.
Mr. Pickles?
And I think the remark
Was it a public service to possibly put members of our security service at risk as a result of what happened?
Well, I think we need to qualify that, but this was absolutely in the public interest. I think if you look at the remarks of Sir Tim Berners-Lee through to the former Vice President of the United States saying this exposed crimes against the Constitution, only this week we had former members of the Church Committee saying that we need a church committee for the 21st century. So it was absolutely in the public interest.
Can I say, Mr. Chairman, as well, I do not believe that the Guardian's publications put anybody at risk. You've had Mr. Rusbridger in front of you. I've spoken to him at great length as well on this subject, and they have been extremely careful to talk to the government, with one exception, which I think was the G20 exposure, which didn't put anybody at risk, a certain amount of embarrassment. With one exception, that being that one, they spoke to the government before every single article was published. So I don't think that the idea they put people at risk stands up at all.
Thank you. Supplementaries from James Clapperson, Julian Huppert, and then Michael Ellis.
Could I just ask Mr. Pickles, in view of the evidence which we just heard, could you just tell us how the bulk collection fits into the picture of warrants?
Well, the one word you didn't hear was certificates. Is that there are warrants and then there are certificates. So Section 8, Section 1 of RIPA allows for warrants, and that's for communications within the UK, the internal communications. Section 8, Section 4 of RIPA discusses external communications, and they're deemed to have a lower legal protection, and this is based on a model where information would flow out and into the UK over copper telephone wires to the Soviet bloc. And so you would intercept every call that was leaving to go to that country. The problem is if you apply that model to the internet, well, you could send a text message or a Facebook message to someone sent a few feet away from you, and it might exit and re-enter the UK. So therefore falls under this definition of external communications. So I think Section 8, Section 4 of RIPA is particularly critical there.
Section 94.
And then we have Section 94 of the Telecommunications Act, which is, I mentioned, and Dr. Huppert mentioned earlier.
Two quick questions. First of all, is bulk collection of what, and who is supervising it?
Well, my letter to BT was asking, do you hand over data in bulk under any authority?
What is the data that's being handed over?
And that would be metadata, the communications data, the who, what, where, when. So that would be for a traditional landline, or on the internet it could be email addresses.
Or mobile?
Or mobile phones, depending on the operators. And my concern is that there is the activity going on under the Telecommunications Act, which is unsupervised, and that's why BT cannot publicly refuse that they're handing over information in bulk.
Right, and I should ask also, who is it being handed over to?
Well, this is the question, is we simply don't know. Questions in the House have been met with the usual response, and companies refuse to talk about it.
I suppose if we don't know who it's being handed over to, we can't ask who's scrutinising it.
Well, the answer to my question was provided by Mr. Birkenshire, so you may have an opportunity. Isn't he appearing before you today?
Yes, thank you. Julie, Dr. Huppert.
Yes, thank you, Chair. So can I just pick up particularly on this thing, Mr. Pickles, that you said about BT being unable to deny various things. Can you just amplify a bit on that and build on Mr. Clapson's questions as well? What exactly couldn't they deny? And presumably if they didn't have any orders under Section 94 of the Telecommunications Act, they could say that they had none. It just bans them from saying so if they do have any. Do you have any sense as to whether this is a widespread thing? Is this a BT-only thing? It'd be very interesting to hear what you've discovered about all of this.
Well, my interest comes from the trip to the US, where it became clear, and this was one of the first Snowden revelations in America, that particularly Verizon Business Services were receiving orders under Section 215 of the Patriot Act, which were intended to be for named records on named customers, and had actually been used to collect information on millions of Americans. And the word relevant in the Patriot Act was the reason why Representative Sensenbrenner, who guided the Patriot Act through, highlighted this, and why the President's review flags that the interpretation of that word does violence to the English meaning of the word relevant. So I asked BT categorically, Does BT provide data in bulk on thousands or millions of customers who are not individually named in a RIPA notice to the UK government or its agencies, and if so, under what legal authority? And I received absolutely no substantive answer to that question. And I cannot imagine, given the severity of what that entails, why they could not deny that.
And presumably if they weren't doing it, they'd be legally allowed to say, no, we're not doing that.
Absolutely.
You would assume so.
Yeah. So there's a clear inference there.
Mike Dennis.
Do you think that it performs a public service, or would perform a public service in this country for officers of any of our security services to steal material from their employers and flee to Putin's Russia? Do you think that would perform a public service?
And would you like to
Mr. Pickles?
Well, I think firstly it's important to note that the reason Mr. Snowden is in Russia is because his passport was revoked, not by any personal choice.
But do you think it would perform a public service to steal material from your employer? I mean, would you think it was a public service if someone who worked for you stole material from you because they thought that perhaps they didn't like something that you were doing, and they fled to Putin's Russia? Do you think that would perform a service?
Well, I think firstly there's a very, very important point here of public interest.
Right.
And Mr. Snowden took a decision that what he was seeing, particularly after a very senior member of the intelligence community told Congress they did not collect information on citizens, which now appears to be a lie, or at least a deliberate untruth, exposing that lie was absolutely in the public interest. The fact he is in Russia was not a decision for Mr. Snowden. It was one forced upon him.
Right. And do you think that it's okay, as a point of principle, for our security services to be able to lawfully access landline and mobile communications of criminals and terrorists, but not computer communication? So do you think there's such a difference in those forms of communications that for decades, perhaps even 100 years, security services or police may have been able to access landlines or mobiles, but somehow computer form communication should be okay for criminals and terrorists to use?
No, absolutely not. And I wrote a 3,500-word article for the Journal of Counter-terrorism earlier this year, explaining how the principles of directed, targeted surveillance should apply on the internet. My concern, and what Mr. Snowden has revealed, is the principles that underpinned previous surveillance, named suspects, targeted investigations, have been abandoned because the technology allowed it, which is why the President of the United States said, just because the technology allows us to do it, does not mean we should.
It also introduces, I may say, some new temptations. When the mechanism was attaching a couple of crocodile clips to an exchange and then listening in, that was self-limiting. Only a few of those could happen at any point in time. So getting a warrant was not an issue. When you are accessing millions or even billions of records, then getting a warrant becomes something of a different problem. And so it does introduce a new problem.
Would you agree, Mr. Davis, to you that by its very nature, our law enforcement must keep up with criminal activity? And if communications have advanced to such a point, it's essential that our law enforcement follows criminal activity. Otherwise, they'll simply be able to divert their criminality from landlines and mobiles to another form of communication.
Law enforcement should follow criminal activity. This is why it was important that the Judiciary Committee in the States, when looking at block metadata collection, the very thing we're talking about, challenged the claim of the agencies that they had stopped 54 plots. It actually started out as several hundred plots. And then it was reduced to 54. The Judiciary Committee went through them and reduced it to one, which was a transfer of $8,500 from San Diego to Somalia. There was not a single terrorist plot stopped by this mechanism. Not one.
Right. Can I just ask Mr. Pickles, is it correct that Big Brother Watch are initiating legal action against GCHQ?
Yes, we have a case pending before the European Court of Human Rights.
You're using the Human Rights Act, are you?
Yes, we are.
And what are you seeking to sue GCHQ about?
But the two specific questions are that the collection of data on millions of British citizens is a disproportionate interference with their right to privacy. And the second argument is that the quality of law means that an ordinary British citizen cannot read the legislation and understand in what circumstances they themselves may become subject to surveillance. And this goes back to the point of RIPA being written before Facebook really existed and Google was still in a garage when that happened.
Thank you very much.
Ask about, you've just come back from Congress, from the United States. You've looked at their oversight, and the heads of their intelligence services have appeared 8 times on average each year before congressional committees. Would you like to see the heads of our services appear more often, not just before intelligence and security, but other committees that may be relevant, such as the Foreign Affairs Committee or the Home Affairs Committee?
Yes, I do, Chairman. I think that it's difficult for them, there's no doubt about it, and they have to have the option of saying, I'm sorry, I can't answer that question. But it has enabled members of the committees, in fact the oversight committees themselves, to put in the public domain things that they thought needed to be known to the public, and in particular excessive surveillance. So I do think it's worthwhile. I actually think we are very similar to the United States. We have the same enemies, we have the same techniques, we have, broadly speaking, the same public standards, and yet they manage to maintain a level of openness in their surveillance which is completely different to what we manage here.
Indeed. Mr. Pickles?
Absolutely, I'd echo that, and I think
they've got a better structure, you think?
They absolutely have a better structure, and I think, for example, that the first time the CIA director appeared on television was 1974. So I was pleased that we finally caught up with that in all this time. And I think one of the crystallising thoughts in the US was that as a result, the oversight committees don't have to act as spokespeople for the agencies. The agencies can defend themselves, and I think in this day and age, when the revelations from Snowden broke, it wasn't unreasonable to expect the agencies themselves to explain this to the public, rather than having to rely on the committees that are scrutinising
Because
them.
they're very well known now, the heads of the agencies. It's not like before when they used to be unknown to the public. I mean, most of them have ended up in the House of Lords.
Yes.
Well, in this country, I mean, the last of the agencies to become public was the SIS, in the 1994 SIS Act. I took that through the House of Commons. And it was an explicit decision by the agency at that point to become public. So with that comes some responsibilities, one of which is... and just on the point of interrogation by oversight committees, Chairman, your committee's already raised with a previous witness 3 occasions when our oversight failed. That was the dodgy dossier, to use the slang, rendition, and 7/7, where they did not highlight the failures there. And they didn't foresee Tempora and Prism either. That is not the case in the States. The Intelligence Committee did foresee some of the issues that Snowden raised, and raised them before Snowden broke.
Very helpful. Julian Huppert, Nicola Blackwood and Paul.
Thank you. Can I come back to this comparison between Britain and the US? I presume you're both familiar with Yes, Prime Minister, and there's a line there, where Desmond Glazebrook says, "Good Lord, no, any hint of suspicion, you hold a full inquiry. Have the chap straight up for lunch. Ask him straight out if there's anything in it. And if he says no, you've got to trust a chap's word." Do you think that's an accurate description of our system? Probably a little harsh. And how do you think it compares to what you found in the US?
No, I think that is a little harsh, but nevertheless, there is a problem of capture. There's no doubt. It happens in the States too. I mean, I met Dianne Feinstein, the head of the Senate Oversight, which is the more powerful of the 2 oversight committees, and she was very, very pro the agencies. She was, behaving in the same way that Malcolm Rifkin behaves, and his predecessors on his committee have behaved. He became like a spokesman for the agencies. But it should be said that last week, I don't know how many of the committee have followed this, there was an upper and downer of a row in the Senate, and what the Chairman of the Judiciary described as the greatest speech ever made in the Senate, when she attacked the CIA for monitoring and bullying the staff of her committee. So there is a robust relationship. And I think the aim when we created the ISC was it would metamorphose into a full-blooded select committee of the House with elected chairman and the rest of it, and that hasn't yet happened. It's en route, I'm sure, but it's got to accelerate.
And in terms,
I think it's telling that that's the combined weight of the President's NSA review, that's the Privacy and Civil Liberties Oversight Board review, and that's the ISC review to date. I think that in itself is quite telling as to how informed the public debate is.
I was going to ask about those 2 reviews. How have they gone down in the US? How have they been accepted? how entrenched are they, and how much resistance is there to implementation of their
Perhaps
recommendations?
the first thing to say is who was on them. I mean, the President's panel was run by Richard Clarke, chaired by Richard Clarke, who was Bush's counter-terrorism head. Michael Morrell was his number 2, I guess, a deputy director of the CIA, very well known to our own heads here. And there were 3 other legal experts, all of them establishment pro-Obama legal experts. And they came out with an incredibly rigorous and robust set of 46 recommendations, including effectively shutting down the mass collection program of metadata, and instantly, while they're at it, pointed out that the American agencies had already shut down on their own accord their email metadata collection program. But anyway, to come back to your point, it was very, very well accepted, and people were shocked by how robust it was, but everybody accepted that it was the way to go.
Thank you. Nicola Blackwood.
Thank you, Mr. Chairman. I just want to take you back to your comments about bulk data versus having individual judicial oversight for each application for a warrant. And putting aside the morality of it for a moment, just ask about practical application. Because assuming that there'll be secret evidence required in order to prove the necessity for an application, do you think that this would have to be considered in camera or in CMP?
Well, there's obviously, the Americans have got the FISA court, which is a secret court. And one of the recommendations from both reviews is that there should be a public advocate there. So there is somebody who can offer a differing point of view, rather than having a one-sided court. Inevitably, you will have to use, I think, closed materials. However, the special advocate system is certainly an option. I think the interesting thing across the board is now we have CMPs and post-justice and security, what purpose the tribunal still serves, given that the courts now have the ability to hear these cases. And the tribunal itself is quite a weak part of the
investigatory powers tribunal,
which allows
so
which is the American
system. So you're suggesting that the investigatory tribunals, powers tribunal, should be overtaken by judicial oversight through CMP?
I think so. So the tribunal as a redress mechanism, not as an authorisation mechanism. If you look at Judge Leon's ruling in the NSA, where he calls bulk collection almost Orwellian, that comes from a public judicial process with a public judgment, and that's very valuable.
Yeah, but once again, moving back to the practicalities, I'm trying to work out how our court system would functionally approve 1,700 warrants through CMP annually, and possibly more. And if you're talking about replacing bulk surveillance as well, I assume that that's going to spike. So I'm just trying to understand what kind of bulk system you imagine
I
would
wouldn't worry about
replace it.
1,700 warrants in a year. That's not very many, bluntly.
No, it's not. But if you're replacing the bulk surveillance as well, and you're having to justify that
As far as we're, there's only 10 certificates that currently exist for the bulk collection under Section 8, Section 4. And this was in the President's review when they found that you could get the same information from traditional investigations rather than using the bulk orders. That was mentioned repeatedly. So I think it's more a mindset change than a bureaucratic change.
There's no problem at all in holding that in secret, holding those hearings in secret. Because after all, we're not talking about locking somebody up, we're talking about just gathering their information. What is a problem of holding it in secret, which manifests itself with the FISA court, is the court changed the law. In effect, the court took a new wording of the law, the so-called use of relevant, and used it to justify mass collection, which is actually a breach of the American Constitution. So the problem of a secret court is simply there's nobody there to test the arguments that are being put and test the judgments of the court. But it's the best option you have as it stands.
Thank you. We need to move on. I think David Winnick has a quick supplementary, then finally Paul.
There's some contradiction, perhaps I'm wrong, between yourself and Mr. Pickles, Mr. Davis.
Entirely possible.
Mr. Pickles said that the American system is such that the chair of the oversight committee doesn't act as a spokesman for the committees. But the criticism of Senator Feinstein is that she has constantly defended the committees, CIA, FBI, or CIA in particular. But the only time she has criticised is in the last few days when she's discovered that the CIA have actually hacked into the phones of her staff who've been probing into the CIA. So
a quick response, then we need to move on.
Very quickly. The committees that are not directly involved are committees like Judiciary, Foreign Affairs, Defence and so on, all of whom have nominees on the Oversight Committee. They don't get captured. The Oversight Committees invariably, to some extent, get captured. Invariably, even in America.
The Justice and Security Act last year is supposed to have made the Intelligence Security Committee a credible, independent watchdog. Has it?
No.
And what should we do?
I've already said, I make it a proper select committee of the House, elected by the House, with the chairman elected by the House from an opposition member.
Okay. I think we're indebted to you for publishing just how much this metadata can tell us. And when you see your activities on one day in Manchester, and I think like all members of the committee, I mean, you're entirely blameless going from one good work here and helping
from one bar to another, isn't it?
No, like that. Oh, no. But I mean, it does seem extraordinary, and there hasn't been a stronger reaction from the public to the amount of surveillance there is on what we'd regard as our private lives. I mean, why do you think this has happened when it's happened elsewhere?
Well, there are several reasons. I mean, the first reason is, to some extent, the fault of the press. The Guardian was very unpopular with other newspapers, and it was the paper running with this story, but because of Leveson, nobody else wanted to help it. Part of it's down to our respective parties. Each of them have become very heavily involved in the process of weighing government and not wanting to criticise it themselves. Part of it's that Brits tend to be more trusting of their own establishment. But that's changing. If you'd done a survey 6 months ago of whether people thought this intrusion into their private lives was important, you would have got a very, very low number saying yes. Now the number's crossed 60%. So it is beginning to gather pace. And that's why I think the Deputy Prime Minister and the Shadow Home Secretary both made speeches in the same week saying we have to get a grip of this.
Thank you. Just final one. Do you, as an MP, believe that you can give 100% trust in what we've been told when there's a next occasion when we're asked to go to war?
No, of course not. We've had 3 occasions, as I said, where the ISC fell down, and they fell down because of what they were told. Not because they were bad people, they're good people, but because of what they were told. So, no, we can't.
Thank you.
Yasmin Qureshi, very quickly, 30 seconds.
30 seconds indeed. When you heard Sir Mark say that he's only looked at 6% of the thousands of warrants, were you reassured by the fact that, in his opinion, based on 6%, that everything was okay?
No, I think the commissioners are good people doing impossible jobs.
It's a very quick answer. Most grateful. Mr. Davis, Mr. Pickles, thank you very much for coming in.
Thank you.
And Mr. Pickles, if there's any further information, or Mr. Davis, you wish to submit to the committee, please let us have it. Thank you. Order, could we call in the Minister for Immigration and